Hello, welcome to the Challa Law Group weekly webinar. And I just want to give it a few minutes to allow people to join, and then we can get started with discussing the hot topics of today. I know that you all are eagerly waiting the election results, as am I, given all the vast new regulations and rules that this administration is trying to push on immigration. So, and that's going to be the key focus of our discussion today. So like I said, I want to give folks some time to join, and then we can get started. And then we'll have a Q&A like we do always at the end. And we request that you put all your questions in the Q&A box and not in chat. It just makes it easier for us to, maneuver and kind of ensure that we get that information from you. So please put it in the Q&A and not in the chat. So let's go ahead and get started. For those of you who have been joining our weekly webinars every week, welcome again, welcome back. And for those of you who are new, we'd like to welcome you to the weekly webinars. The purpose of these webinars is to make sure that we put out, clear information on the latest changes and provide some strategies to help you maneuver, the immigration landscape. So let's get started. Now, there are different ways to connect with us, and we use these different vehicles for a number of different ways to communicate the new changes. There's Facebook and Twitter and Instagram and YouTube. And we also have a Telegram group. So if you're not part of the group, I think somebody from my office will make sure that they get you the information so you can be a part of our Telegram group. I know that I have not been very active for the past 1 week. We have been just busy with adjustments and trying to make sure that our clients' needs are met in that respect. So, but I will be back on this week and connecting with folks in that capacity. So, as I stated, we do these weekly webinars, and they're video recordings of the webinars on YouTube. And we've gotten a lot of really positive feedback about that. Folks saying that they found it to be very helpful, and it's explained in a way that the average person can understand and then make informative choices. And we have them from a whole different range of things. It's anywhere from talking about how to respond to RFEs, or what are the key things you need to start a PERM. So please, subscribe to our webinars and on YouTube, and comment and share with your friends. We'd love to hear from you. Okay, today we're going to address some of the DOL rules that DHS and DOL rules that'll impact H-1B visas as well as PERMs. PERMs, you asked. Yes, because anything that has to do with wage, there will be some changes with the new wage system that would impact that. We'll talk a little bit about, the challenges to that and how this current election may impact some of these changes. Then the USCIS has proposed new restrictions. My thoughts on that, and how will they prevail if they are challenged? How will the USCIS prevail if they are challenged? And a number of other things, a November visa bulletin, the I-944, which has now been enjoined, and a nationwide, it's a nationwide restriction to impose the I-944, and the new rules for cap season this year, and how they're going to look at wages instead of looking at going through their own, previous systems. So this gives us a really clear indication, a loud sound from this administration as to how they're going to make things more difficult, which is why this election is so critical. So the DOL protection rule, which went into effect immediately, any LCAs or prevailing wages that are filed after October 8th have to adhere to that new wage. So you may have noticed when your folks have been filing a new LCA that the wages have gone up, and they've gone up pretty substantially. As you can see, it went from the 17th percentile to the 45th, and let me see, 34th to the 62nd, 50th to the 78th. So the wages have increased tremendously. And the prevailing wage, the rule is that when you file, for example, an H-1B, you are stating that you will pay either the higher of the prevailing wage or the actual wage. That's what the employer is attesting. So what is the actual wage? The actual wage is what the employer pays other employees with the same education and experience as the H-1B employee. So, and the way they assess that is in the public access file. The employer actually has to put the wage assessment documentation. And then, as we said, it impacts any prevailing wages that were filed after October 8th. So when you go through the PERM process, so how does it affect your permanent residency if you haven't gone through the PERM process? If you're going through the PERM process, you file a prevailing wage with DOL. They will apply these new wages if it's been filed after October 8th, or they're pending on October 8th. The problem with this for permanent residence process is stage one, when you go through the permanent residence process, is with the DOL. Stage two is with the USCIS. And at stage two, one of the things that you have to do is you have to show that you are paying the prevailing wage. One of the ways in which employers have been able to demonstrate that they're able to pay the prevailing wage is because they have been paying the prevailing wage to the employee. So if the wages have all of a sudden increased, for a wage that you had deemed to be closed, because that's one of the things we look at. We don't wait for the I-140 to assess if there's going to be any issues on the I-140. We try to look at those issues at the DOL level before we even file the PERM. So we try to look at ability to pay. And so, if you filed it in anticipation that it would be the wages as they were outlined in July, and it's still pending because it takes, I think 9 weeks for DOL to issue a prevailing wage, and now you're stuck with a higher wage, and there may be ability to pay issues. So there's a number of problems with the way USCIS and DOL, rather, impose these new wage obligations. There have been many lawsuits with regard to this. In fact, the ALA filed on October 17th, and they are all the lawsuits are asking the judge to issue, to enjoin the rule so that it would no longer be effective. So if there's any indication as to what the district courts have been ruling for a number of the initiatives, anti-immigration initiatives that this administration has been proposing, then we would assume that you're going to get a nationwide enjoyment. Until then, this is what the rule is. Now, it is, because the way the wages are set, it really impacts academic institutions. It impacts doctors that are working in, rural areas, because the wage is just so inflated that it would be impossible. Now, in this pandemic, if rural areas cannot hire H-1Bs, then they wouldn't have any, the vast majority of healthcare resources, our medical doctors that are in the rural areas are H-1Bs. And that's because when medical doctors try to do their residency here on a J-1, they're subject to a 2-year home residency requirement. And one way in which they can get over that 2-year home residency requirement is by working in an underserved area. So these wages would really detrimentally impact those doctors in the underserved area. So along with the lawsuit filed by ALA has been academic institutions, and I think it's 17 other organizations that have joined ALA's lawsuit in filing against the DOL wages. So pretty confident that they will prevail because there was no notice and comment. All federal agencies have to go through the process under the Administrative Procedures Act, the APA. And one of the mechanisms of that is when the agency is changing a rule, they have to go through the notice and comment period. The only time that they can overcome that is if there is a major emergency. I don't think that they would prevail on saying that there was a major emergency. In addition, there is a reliance argument. So this rule, because it affects those prevailing wages that were pending, would also, with people relying on the old wages, it would detrimentally affect them. So I think there's a lot of arguments to say that this will be overturned. This is separate from the DHS rule, the immigration rules that will impact specialty occupation, third-party work sites, and such. So for that rule, the effective date is December 7th, 2020. And any petitions filed after that date are going to be impacted by the new rule. I actually used the new rule to respond to a request for evidence on specialty occupation, where the USCIS stated that an engineering a requirement of a position that just says engineering without specifically stating what type of engineer was not deemed a specialty occupation. And I said, if this is your current rule, then why are you amending it? Because that's precisely what the issue is on one of the issues. So they want to amend the rules to narrow the definition of specialty occupation. There are a lot of legal challenges to this as well. And the reason it will prevail is a federal agency cannot legislate. Congressional intent, they have to make sure that any rules and regulations adhere to congressional intent when Congress first enacted this rule. So specialty occupation was not in the definition of H-1Bs until 1990. The IMMACT 90 Act. So it's clear within when they issued regulations pursuant to that, there is, and we have it, detailed discussion on specialty occupation. And that time they said, Congress, really considered this. And in fact, they said, we're going to say a specific field, which is different from a specific degree. Engineering is a field. Mechanical engineering is a degree. So they said, we're going to narrow it, keep it broad to a specific field or specific, disciplines of specialties, as opposed to a degree. Secondly, within their discussion, they stated that they understood that sometimes degrees like business administration, which are so general, that it doesn't align to doing a specific specialty occupation type job, can sometimes still be helpful if you look at that in conjunction with the work experience. So what does that say? That means that you can't really say that this degree is for this job because of the growing technology and the growing changes. And in fact, in my RFE, I cited an article by an MIT professor who said, MIT is the premier, engineering school in the world. And so they stated that there's changes now in American universities to stop making engineering programs really very narrowly tailored as it was back in the day. And so you will see engineering programs like electrical engineers will have a lot of computer engineering classes, even though their degree may be in electrical engineering, because now circuits are not just power grids, circuits are microprocessors. And so with advancing technology, all these, not only in engineering, but in a vast majority of disciplines are changing. We've done work for user interface. And the Cornell School, in fact, has a very good kind of hybrid program where you can be an agricultural grad and still work in innovative technologies. So you can't look at job titles and academic, programs without looking at the advances that are being made in technology. The job titles were written in 1990. That we didn't even think at that time that we would have an appliance that you could, with your app, have it vacuum your home. We didn't think at that time that you could have smart kitchen products that you could use with an app. And so with those technologies, the field is changing. So because Congress specifically spoke to that, the USCIS can't change the rules to contradict what congressional intent is. So I think that these lawsuits will prevail. And so the issues of, and I knew that specialty occupation, third-party workplace, and employee-employee relationship would be the issues that the USCIS would try to address. Why? Because there were court cases. Last year, the Supreme Court decided Kaiser versus Wilkes. It was a very important decision for Administrative Procedures Act because Kaiser versus Wilkes clearly outlined when there should be deference given to an agency decision. And they have stated that it's only when the language within the statute is ambiguous. If it's unambiguous, you have to go with looking at the constructions of, their legal construction tenements that you would have to look at. And so one of them happens to be the plain meaning of the statute. So specialty occupation, specialized knowledge is knowledge within a specialty field or discipline. It's very clear that if they intended to say degree, they would have said degree. And post-Kaiser, you remember all these lawsuits that came up for H-1Bs in favor of the H-1B beneficiaries and struck down a lot of decisions that the USCIS made. And they happened to be in the area of specialty occupation, third-party worksite, and employer-employee relationships. So what the USCIS, they knew that they wouldn't prevail in federal court. So they decided to change the rules so that they could move forward. But the problem is, if a federal court has already deemed that you have, you as an agency have gone outside the scope of the plain meaning of the statute, then it's clear that a federal district court will strike down this new rule and enjoin the USCIS from enforcing it. The question is timing. They've already been filed, and I suspect in about 2 weeks or so, we may hear something. I know that most people are trying to push to get before a judge before the effective date, but we'll have to see. So that's why it's important you connect with us on social media so we can keep you up to date on the latest changes. So we talked about the definition of specialty occupation. As I said, it says requires an attainment of a bachelor's degree or higher degree in a specific specialty or equivalent for its minimum entry into the United States. And one of the things that we have done since, about a year and a half ago, is we try to make sure that our job description is not generic. And we try to show the connection between what the person's education is and what type of work that they'll be doing. If you use really generic job duties, then, and that is exactly what has been mimicked by the federal district courts, that the job duties have to be detailed. And so, usually people do that when they're submitting an RFE, but if you do that up front and make sure it's specific to your project. So if, for example, you're an ETL developer, right? And you're doing it for a specific project, make sure that you don't just give general, we look at architecture, and the average USCIS person will not know what that is. You'll have to explain what ETL developers do and outline, the architecture and, how you're getting large data and you're having to put it in place for doing X, Y, and Z. And so the more specificity that you can provide, the better chances you will have. Because like I said, that is one thing the federal district courts looked at. So like I said, they want to make it so that it has to be a specialization, which, take me for example, and they cite to this quite often, that lawyers, if you've got a law degree, then we know that you will practice law. We have an engineering degree, you know that you'll do engineering. But I've got a law degree, but I'm practicing immigration law. I do have a specialization, right? And, but I don't have a degree in that specialization. Just like you have doctors who, through practice, may over the years, have a specialization that they are focused on, but not necessarily have an advanced degree in that area. So there are many issues and loopholes and problems with the specialty occupation definition. And then they, typically before the petitioner would just attest that they normally require a bachelor's degree. Normally means sometimes, right? Sometimes not, more often than not, commonly. And you may have different people with different backgrounds and degrees. So, an employer may have software developers, but the software developers could be working on various projects. So you're looking for a different skill set based on that project. So if you've got a project with the healthcare industry, you may want to have someone with that knowledge base and with that experience. So that's why the devil is in the details. Sometimes it may make sense if you have to file after December 8th and this rule is not enjoined, it may make sense to get an experiential evaluation of your degree. That means even though you have a U.S. master's degree, if you have extensive experience, get an evaluator to say that it's equivalent to, a specialization or a specific degree. Make sure that, you look at all these issues when you're trying to figure out what job title you're going to use. So these are some of the things that I would suggest if you have to file in after December 7th. So they're also going to limit the maximum validity for H-1Bs to 1 year if they're at a third-party work site, other than the beneficiary's residence. So if the beneficiary is working at home, this would not take place. So right now, because of COVID, I know a lot of people are working from their home, and that may be a way in which to get through this. especially if we know that, for example, our new president is going to be President Biden, because one of the things he's going to do is strike down all these restrictive immigration restrictions the first day he's in office. So you want to see how you can get through until you can file an amended petition post-Biden presidency. This has always been the rule. As you know, the USCIS uses the tax code definition of employee-employer relationship. So they want to narrow the rules so it is, you can show the control. I always tell folks to do that anyway. Even if your employee is at a third-party site, or you're an employee who's working at a third-party site, make sure your employer, you have some sort of mechanism where you're checking in with them weekly. And these weekly meetings, even if it's through email, Skype, or project management software that you're using, that they're documented, so you'll be able to present it. That is great evidence of showing that the employer has control over the employee's work, even when the employee is not working directly on the work site. Removing the word contractor, you have to be a full-time employee to do the H-1B anyway. So it really, even though you may be working as a consultant, really you've got to be a full-time employee. So you're supposed to use, in 2010, Newfield memo actually talked about how you demonstrate employer-employer relationship. And there's a number of ways in which you can do it, but the USCIS has to look at the totality of the circumstances. And so by narrowly saying that only this would control, again, I don't think that challenge will stand. Now, I'm trying to remember the name of the case, but there was a federal district court case decided post-Kaiser that actually looked at the USCIS's 2017 rule that required contracts for third-party placement throughout the validity of the H-1B and said, you can see that they have work. You can't deny the H-1B based on not having one documentation or the other, because the standard is not, is there sufficiency of work, right? So it can't be anticipated, but it can be, can you demonstrate that there's a high likelihood? So it can't be speculative, but it can be anticipated. I'm sorry, it can't be speculative. That means you can't make up, I'm going to try to find work for this person. That's speculative. But you can say, I have these projects, I have these contracts. So there's a high likelihood that even after this contract ends, I'll have another contract, or this contract will get extended. So that is anticipated. And so that's the standard, and that's what's written in the regulations. So I don't believe that this again will be upheld. This is just going through the factors of what constitutes, employee-employer relationship, and it's not one. So breaking, I think. Someone sent something. Oh, wow, very good. I've just found out that the 7th Circuit has stayed the federal decision that vacated the public charge rule. So the I-944 is required once again. That's really too bad. So the 7th Circuit, if you remember, 2 days ago, the federal district court actually enjoined the enforcement of using the 944, right? then it was appealed. So you have the Seventh Circuit Court of Appeals that then stayed the federal decision that vacated the federal charge rule. So now the I-9444 is required again. So this may go all the way up to the Supreme Court, in which case the Supreme Court would apply the Kaiser rule. And in thinking about how Kaiser would be, you know, and it applies differently in different areas. So we'll look into that, and I'll try to put something out about how within the Kaiser analysis, the I-944 rule or the public charge rule would prevail. This is more of the employer-employee relationship, you know, benefits. Do they give you a cell phone? Do they give you a computer? Do you check in with them, you know, on a weekly basis? Are they controlling your work? Do you have to ask them if you're taking a vacation, or, you know, you're running late? So basically, you know, those are the areas in which you would show employee-employer control. One of the other things is work product. Now, work product, if you are doing project-based work, a lot of times the work that you're doing is going to be owned by, you know, the end client. But if you're using instrumentalities like tools or any type of IP that's related to your company to actually work on the project, then, you know, that also helps with your employee-employer argument. So there may be site visits at headquarters or third-party work sites, and they're going to increase the site visits. And if they are refused entry, that may ensue denial of the H-1B petition. So not a surprise. You can file extensions early, before the December 7th, if you are able. Remember, you have to file 6 months prior to your expiration. Or what you can do is, if you are going to require that the employees now work at their home site, if they're working at a third-party site and you don't want to have a limited one-year validity, you can file an amend and extend, right? So if you file an amend and extend, then you would be able to get that extension along with the amendment, whereas with the sheer extension, you can only file it 6 months prior to. And that way you're getting it in before the new rules take place, so you can get a greater than 1 year validity, which you could even after December 7th, because third-party work sites, a person working from home does not constitute third-party work site, but they would still be subject to, you know, the specialty occupation employer-employee issues. So another rule that the USCIS has published is that the wage selectum system for H-1B caps, they've got a very short comment period. Usually the notice and comment is much longer. And instead of choosing randomly, it would be on the basis of the highest wage. That is ridiculous. That means, you know, the researchers would be impacted. Academic institutions would be impacted. There are school teachers that are on an H-1B. Again, they're doctors that are working in underserved areas. And to base it on, you know, the highest wage would be, there's no way that this is going to prevail. And then let's say you file under the cap on a higher wage and then subsequently try to amend it down to a lower wage. They say that they will keep track of that and they will deny the petition. This is just horrible. And before I forget, there's also been another lawsuit filed on behalf of H-4s, because the time frame that it's taking for H-4 EADs to be processed is too long. They don't allow H-4 EADs to automatically have that extension benefit provided to other EAD recipients. And so they're saying, it's now, I think it's almost 18 months to adjudicate it because of the biometrics and everything else. So this is also another case that we're looking out for. So depending upon the outcome of the election, all these things will be impacted. Now, the I-944, as I just announced, the Federal Court of Appeals in the Seventh Circuit has stayed and vacated, stayed the federal decision. When they stay it, that means they basically dismiss it. And so, because the federal district court vacated the public charge rule and the requirement of the I-944, now the Court of Appeals said, no, we're going to let that go forward. So that's the Seventh Circuit Court of Appeals. So like I said, because the federal district court, there is the Court of Appeals for each circuit. And then, of course, above that is the Supreme Court. The November visa bulletin, we were so excited when that visa bulletin was finally issued because we were trying to quickly get out, all the adjustments before the deadline. So, you still have time if you're still thinking about downgrading and filing an adjustment, this is the perfect time because you've got till the end of November. And if you want to figure out, should you do it? What are the issues? You may want to look at some of our previous webinars. We go into it in depth. I kind of walk you through what the pros and cons are for downgrading and filing an adjustment and what issues you should look out for. Next week, we'll have another webinar. I'm sure the USCIS will give us new topics to talk about, new restrictions down the pipeline. But if there's something specific you'd like us to cover, please email us and let us know at info@challalaw.com what it is. And my team has also sent out a link to our Telegram group. That's a group where, like I said, I haven't been active past week because we've been busy, but I'll be active back on that. And we put a lot of resources so we can communicate and talk to folks directly. I love that. I love being able to, connect with people that way. The Challa Law Chat group forum is where we want to make sure that we're able to give out. And a lot of those people that are on the forum are not even, they've got their employers have their own attorney. So the main purpose is to make sure that we get information to you. There are different ways to connect with us, so please connect. And like I said, check out our previous webinars on downgrading. And somebody requested the Telegram link again. So if you could just share just that particular link, Kara, that would be great. And now we're ready to, like I said, previous recordings are on YouTube. And I loved hearing from folks that have said that they found it really very helpful. So that's been wonderful. And you can always email us if your question does not get answered today at info@challalaw.com. Subscribe and look forward to connecting with you. We're now going to get ready for our Q&A section of this process, and Shaker Challa will moderate the questions that are asked on the Q&A. And like I told you, I said, don't ask the questions on chat because it's
Hello.
there, you're unfrozen.
Hi. Okay, can we start?
Yep.
All right. Good afternoon, everybody. Thanks for submitting some questions. I'll start with the first one. Nisar is asking, last month I filed I-485 for my 15-year-old son along with me, priority date of March 2014. if we did not get green card by his 21-year age, what should I do to avoid any issues for applying for his F1 visa?
Probably not, because you're going to do it in the United States, but you said he's 14. And if you filed,
15.
huh?
15.
15. And did you file just the 485, or did you downgrade?
Doesn't say anything there.
Okay, if you downgraded, I need to know if you filed a new petition, because if you file a new petition, that's one of the strategies. You get to benefit from the CSPA. So, but it would only apply if it's a new petition and not really an amended petition. But that would have been a mechanism by which you could gain some more time.
All right. The next question is from an anonymous attendee. My visa was approved and not with updated I-94, and now the consulates were closed to step out of the country. Is H-1B extension possible, and is there a way to get updated I-94 now being in country?
Why didn't you? I'd have to look at your case to see why you didn't get the I-94. Was there a status violation? Because when the USCIS adjudicates a petition, they do two things. They adjudicate the underlying petition, and then as a benefit, they issue the new I-94 card. In instances where there's a status issue, they may approve the petition, but they won't give you an I-94 card. So we have in the past, it depends on, how long, if it was an extension, how long ago you filed the extension, and, your I-94 card expired. What period are you in now? Can you file an amended petition and get a new I-94 card to try to rectify that and ask for discretionary relief? There's a number of things. And if none of those things apply, you may want to think about going to Mexico and processing there. And it would, but the likelihood or that you would have an issue going to Mexico would all depend on the details of your case.
So Nisar, who asked about his son, 15-year-old, followed up, and he said, it is a new petition as my EB2 was revoked by my current employer and I left them. So his question was about his son, the first question.
Right. So while the EB2 new petition is pending, because remember, you filed the adjustment and then you filed the EB2. So the adjustment, because it's based on final dates, does not in and of itself freeze your son's age. But the new EB2 or new petition that you filed does freeze your son's age. So while that's pending, that's some time back that you would get before the age out issue prevails. And so you may want to think about also, starting another process because they revoked your petition for the EB2 as well. And that way, if EB2 advances, you have that benefit in addition to this.
All right. So go to the next question. Fanindra Namburi. My PD is current on EB2 for filing date, and the PD date is March 18th, 2011. And if EB3 moves to current in final action dates in future, then can I downgrade to EB3 while EB2 I-485 is pending? If yes, then do I need to apply my I-140 in advance to EB3, or can I do it while downgrading? What's your suggestion? I think she's attorney's frozen there. Let's wait for Lakshmi to reconnect.
Hello, I'm back.
Yep. You want me to read the question again, or?
Please.
Fanindra Namburi is asking, my PD is current on EB2 for filing dates. His PD date is March 18, 2011.
Mhm.
And if EB3 moves to current in final action dates in future, then can I downgrade to EB3 while EB2 I-485 is pending?
Yeah, you would have to file an amended petition, but you can.
So if yes, then do I need to apply my I-140 in advance in EB3, or can I do it while downgrading?
You could. That way you would, instead of the benefit of doing it now and doing the amended now, not amended, but a new petition for EB3 now, is that, remember, when you are filing a I-140 petition where you don't have the original PERM, you can't do premium. So that process is going to take longer. So that is something that you could do in anticipation of that. And then all you would have to do is, if EB3 does advance, once the I-140 is approved, you just have to do an interfiling and you wouldn't have to file a new adjustment.
All right, next is an anonymous attendee. Any update on EB2 to EB3 downgrade filing receipt notice? Have you guys started receiving the notice in your firm?
So I believe we have for a few. And one of the things that you can do is, if whoever wrote the checks for your adjustment petition, once those checks are cashed, on the back of the check, the receipt number will be written. So you can look to see if the checks have been cashed.
All right. Next one is an anonymous attendee. Prevailing wages filed for PERM with DOL. Can the same documents be used to file LCA for H-1B?
You don't need to, because for PERM, well, if it's still valid, it's usually valid for a certain period, but the regulations state that if you're filing a new LCA after October 8th, then you have to adhere to the new wages. So it wouldn't help you if that's what you're trying. If you're trying to overcome the new wage, the increased wages by how the regulation is outlined, you have to adhere to the new, even if you've got an old prevailing wage that's still valid.
All right. Another anonymous attendee. My EB-140, I-140, EB-1 I-140 is not approved yet. Since OCT visa bulletin, I guess OCT October visa bulletin filing dates are moved, my company filed AOS based on the I-140 receipt. What are the chances of getting EAD AP cards without having approved I-140? And what will happen to EAD AP cards if I-140 not approved?
Right. So good question. Two things. When you've got your I-140 pending, and then you've got an adjustment of status, they're parallel processes that are happening. It is your adjustment of status where you're going to get an EAD and AP pursuant to that. There'll be a biometrics interview. after the biometrics interview, that's when you would get your AP EAD. Now, since your adjustment is based on the I-140 filing, if that's denied, then your adjustment's going to be denied unless you have something else.
All right. Another one, anonymous attendee, where can you go to check what your new wage would be compared to what it is now? Or what is the range for these wage levels to get a gauge?
Right. So you would just Google Department of Labor wage resources, and you should be able to find that.
Just a comment from one of the anonymous. You answered for the LCA filing. He said, thanks for understanding. That is exactly what I was trying to do, to use the old one to file LCA.
I know. That would have been nice, but I think they kind of figured that people would do that. So that's why they wrote the provision accordingly.
Next person is Moksheda Tapal. He's asking, I think it's a he, since the DOL wage increase went into effect immediately, is there any benefit to commenting on the rule now? Not sure what that.
It's just if, you know, a lawsuit's filed, that would be.
You were frozen for some time, so maybe you start answering that. I can start the question again. I think you're frozen. You're freezing again. Hi, you're back. You're back.
Yeah,
You were frozen for some time, so I don't know if the answer was heard. So the question is, since the DOL wage increase went into effect immediately, is there any benefit to commenting on the rule now?
well, I don't think the Department of Labor or the U.S.
Something is not working with her video streaming. Apologize for that. Hello?
Yeah, for some reason it's kicking me off.
Yeah. So that DOL wage increase question is throwing. I haven't heard it. I don't know if the user, if the person who asked the question heard your answer.
Okay.
Since the DOL
Yeah,
rule,
I know. Don't worry about commenting.
okay. Anonymous attendee, if your degree is from the US and you need to get it looked by an evaluator to show up specialization, who are these evaluators who can look at it?
Your attorney should have a credentials evaluator. And there are very specific requirements when it comes to using experiential. You may not need to if you've got a specific degree. It may be the job title that you want to pick, maybe a little different. So there's a strategy to this.
I think she's having a tough time to get connected today. So just,
that is not a cookie cutter. So you
yeah,
kind of look at what the job duties are, what's the job.
what I'm suggesting to the viewers who are there, participants, is I think, we have 3 more questions. So I have a question from Rahul, a question from Rama, Meragani, and Liza. So those are the 3, and I think there's just another question just came. So we'll just stop at that, and then because of the connection issues that the attorney is facing, then you just send your question via email, info@challalaw.com. Apologize for that. So when she comes back, I'll announce the same thing, that we'll stop at the next 4 questions. The last one received was from an anonymous attendee. So we'll have Rahul, Rama, Isa, and an anonymous attendee. So please, hold off your questions, and just send an email to info@challalaw.com, please. So that way your questions are answered, and don't have to go through this reconnection. There must be something wrong. Internet connection out there. I think there's a question from Suchi Batra. I think we sent an email responding to that question about biometrics appointment and misplacing the ASC notice, the original. So I think we already said that, although the inspector or the USCIS person probably would like to see the original, but they were able to see and have your kids do the biometric appointment with the copy. But that was what we know last, but things could have changed. But I'll ask the question again when Lakshmi comes up to see if what she has, if she has to add anything to that.
Okay. Sorry, guys. For whatever reason, been having
Right. While you were not online, I told them that, because of these frequent issues on connection, so we'll just finish with 4 more questions that we received.
Okay.
Then I requested them to email,
Perfect.
so the next question is from Rahul. November 13th, there is a court hearing on wage level related litigation. What are your thoughts and chances we get injunction?
Hopefully, a good one. And as I stated, part of the lawsuit, their universities, their hospitals, there's a number of organizations that would be negatively impacted, especially because they didn't do a notice and comment. They didn't give any opportunity for these institutions to adapt. So even on just that measure alone, I think it would prevail.
Okay, Muksheda Thapa, whose question you were answering and got cut off many times, says, thank you for the webinar. This was very useful. I look forward to the next one.
Well, let us know what topics you want us to cover.
Thank you, Muksheda. In spite of when she was answering your questions, you got frequently disconnected. All right. So let's go to Rama Miragani. I filed my 485 alone in October 2020 since my family members are in India. Can I file 485 for my dependents now in November once they are back to US? If so, what are forms I need to file, and do I have to wait for the receipt number?
I don't know. Well, if they're back in the United States and your priority date is current, then you can have them join your file. You want to make sure that you join them if you don't have a receipt number yet, check on the checks, the back of the check. There may be a receipt number. What you could do is submit a copy of the filing, not the entire filing, but just your I-485, your I-140, and just say that these are the family members and they want to join that adjustment application.
All right. Next one is Liza Swatova. Sorry. I am on F1 OPT and I have got a government fellowship offer that requires J1 status. When premium processing will become available, will premium processing become available for J1 applicants? Or
well,
I think when premium processing will become available for J1 applicants.
Yeah, so what it would be a change of status that you would file if you're currently not on a J. And you would file, actually, there's no I-129 petition for J, so you'd file an I-539. So there is premium processing, I believe, in place for I-539s. It's effective. It's not a 15-day turnaround. It takes longer. But we talked about the new premium processing, the expanded premium processing in our previous webinars. So you can take a look at that to see. I think it would be 2 weeks ago that we talked about it. So it's not so much the classification, but it is the form. So for F1s, if you're changing from H1 to F1 or H1 to J1, you'd file an I-539.
Okay, I got one new question from somebody, so we'll take that before we close. But there was one question that was, the email was sent and we answered, but she's asking again, Suchi Batra, but my kid's H4 biometric appointment in 2 days, I misplaced the original ASC appointment notice, but I have a copy with me online. Is this sufficient or should we?
Yeah, you should be fine with a copy. You just let them know that you misplaced the original.
Okay, just want to make sure, because that's what we answered, but since you're online, I thought, So anonymous attendee, I filed for new I-140, 485, AOS, and AP under EB3 with intent to start using EAD after 6 months. I have an approved I-140 under EB2 with June 2014 as priority date. In future, if EB2 action dates move faster, can we amend my EB3 140 back to EB2?
Well, if you filed a new EB3 petition, instead of amending, when you downgrade, you can either amend or file a new. If you filed a new petition for EB3, then your EB2 still stands. So all you'd have to do is, if the EB2 numbers advance, you would interfile to the adjustment and just let them know that you've got an EB2 approval notice. What I would tell you, if for anyone, if you're going to use your EAD and AP pursuant to the adjustment filing, make sure you don't use it to work for employer other than your H-1B employer. You want to have the safety net of the H-1B. We don't know who's going to be our next president yet. We don't know what the outcome is. And, hopefully it's President Biden, so that we can have more favorable adjudications. But that is something that I would do to make sure that you have a safety net.
All right, Liza just said thank you much for your information. The question on J1. There's a question, I think this will be the last question. I think there's one more. Somebody said their question was not answered, but I did not see that question. I picked every question, but that person anyway asked the question. So that will be our last question, like I said. So after that, we will not be, we'll have to execute all the petitions that the team is working, right? So we would definitely entertain you sending questions by email. So this is the penultimate question, and then the last anonymous attendee. Sai Sagar Adimulam. What is the minimum wage level requirement for master's degree with 5+ years of experience? With this new wage level, if I am meeting level 1 requirement, will there be any issue for H-1B extension?
It's not what you have, it's what the job requires. So it depends on the job title. It depends on things like, do you have any supervisory duties? What was your previous H-1? A lot of people are amending and choosing a lower level now. And if you do that, I'd file it regular. Let's hope we have a new administration when it gets adjudicated and this would no longer be an issue. But, I can't tell you based on what your background is, what the wage level should be. It would have to be based on the job duties.
All right. So this anonymous attendee, the last question for today.
Mm-hmm.
I am in 60-day grace period from mid-September 2020. My AOS 485 EAD application has been filed with my spouse's application as derivative in October 3rd week. My H-1B transfer from a new employee A has also been filed in October 4th week. That is his background information. Now he's got two questions. First is, can I decline joining the employer A and not start employment and still be in legal status based on AOS 485 EAD filing? Will my legal status be defaulted to AOS 485 EAD when I don't start employment with employer A, or do I need to trigger something with USCIS to activate my AOS 485 EAD status, because both AOS for EAD and H-1B applications are in process in parallel? Are there any risks?
Well, to give you some context, when you file, for H-1B visa holders, you can have it's dual intent. You can intend to reside here temporarily, and you can intend to reside here permanently. So you can hold an H status and an adjustment status at the same time. Since your adjustment was filed within the grace period, I think you would be okay. But I think what I would wait for either wait for the H to get approved and then file for an H4. But I would have some sort of underlying status other than just your adjustment. And there's nothing that you need to do to effectuate it. But I would have another underlying status so that you have a safety net.
The second question is, if I join employer A via H-1B and quit the job after a few months, will I be defaulted automatically to AOS 485 EAD status to be in legal status, or do we need to trigger something to USCIS to get AOS EAD 485 status while staying within the United States?
Same thing. Yes, you can just have an adjustment of status. But if anything goes wrong with the adjustment, and sometimes the USCIS makes mistakes, even in the best of administrations. And so if it's denied, even if it's incorrectly denied, you will have a status issue. So I always tell people to have an underlying non-immigrant status, even if it's an H4. You don't have to have the H1, but you can have an H4, just so that you're protected in case something goes wrong.
Okay, there was one question earlier, Jay Agnihotri. The only thing that came up was thank you for your attendance. Thank you for your, but the question came, I don't know how I missed it, but I'll just ask, how will the priority dates progress? My priority date is July 2010, which is 9 months out from current visa bulletin date of September 2009.
Well, if you're in EB2, as you can see, the EB2 has not progressed that much, and it hasn't changed. October to November, it hasn't changed much, even though Oppenheimer, who is the one that publishes and discusses the visa bulletin, said that they should move rapidly. What does rapidly mean? I don't know. There is an excess of a vast number of slots that are open. Just depends on how many people are filing, how many family members are. So unfortunately, I can't opine on that. We do listen to weekly, we listen to the roundtables, and we try to publish, the discussions of that when we do hear about it. So if we do listen to another Oppenheimer roundtable on the visa bulletin, I'll be happy to update all of you. So that's why it's important you join our Telegram group, because that's where the information will be pushed.
All right, his second part was, how do you think I-485 processing time will change given the flood of applications? So typically, if it took a year to process, how long would it take now?
It's gonna, unless they assign additional resources. So there could be a lot of things that happen. With the new administration, there'll be a new budget. So if they can allocate some money for the USCIS so that they can hire more people, I think, because that's the problem right now. And there's an undue delay with all processes. So this is something the Biden administration would have to take up. If President Trump is our president, then they want them to be delayed. So it will be beyond the 1 year that it's currently taking for processing.
All right. So that's about what we could answer. There are two questions, but as we keep on answering, I think this.
Now I got to get back to work.
Exactly. So I suggest there's a question from Arun Kumar. Please send the details because your question is not very clear. So that's why I'm not able to ask on the air. And then there's another anonymous attendee at 1:15. So that person might have just put the question. But these two individuals, please send your questions to info@challalaw.com. A little more details, any documents. Every time you send us a question, there's one thing I just wanted to say, that give us as much information as possible. If you have a document, put it across, attach it, any information that you can, because what that does is that actually fast enables the attorneys to respond faster. Otherwise,
Right.
we'll have to go back and forth, and that may delay, a
Right. And
response.
I also want everyone to know that we try to get to the questions as quickly as we can, but we're doing this out of a service and we're flooded with questions. And so just have a little patience with us as we're going through that. We'll try to get you your answer as quickly as we can.
So on a good note, Suchi Batra says, thanks a ton for the information on the biometric, notice, So
Good,
thank you
good.
all.
Good luck
And,
to you.
leave Lakshmi to close.
Yes, so thank you again. If you liked our webinar and you found this helpful, send us a note, and so we can, use that because we really do. And it takes a lot of effort to put this together. It's not, and it takes a village. Kara Wood spends a lot of time putting this together, Shaker, and we all, my whole team. So it's great that you appreciate it. Share it with your friends, let your friends know about it so we can increase our reach. And thanks again.
Before you leave, here's an opportunity that I know you love to, although you have to go back to work. There's a question, any comments on elections?
I'm surprised you allowed me to answer that. I figured you'd probably try to hide that question from me. Yeah, I mean, I think I'm feeling very positive. If you just have seen for nothing else but the assault on immigration, and they're trying to do it, they wanted to get rid of the H-4 EAD. They couldn't do it directly, so they're delaying. It's taking 18 months now for people to get an H-4 EAD. It's the denial rates are higher than ever. So in addition to all the other things that may be more political, for that reason, I really wanted a new administration, because it's really important to, you're the reason why our economy is thriving. And you're what makes America great. That's what this country was founded on. And so they are saying that, as the mail-in ballots are being counted, you can see that Biden is, and it's most of the Democratic districts. So there's a good chance that he's going to get Georgia, hopefully. I think Maine is maybe a split state. Then we have, let me see, I'm trying to think, Michigan, and there was one more that they were stating that may go to Biden, which would bring him over the 270. So fingers crossed. We may not know till tomorrow, because I think Nevada has a few jurisdictions, but they're not going to give an update till tomorrow. And some places like Philadelphia, I think he's got a strong chance, but they've got till, I think, Friday to get in. The ballots would have just had to be postmarked, but don't have to arrive in Pennsylvania. So you may have more people, especially in Pittsburgh and other areas, and with ballots coming in.
All right. Just wanted to say, Rama Meraganini, we answered your question, but you may have missed it, or if it was answered and you know, when Lakshmi had some connection issues, please submit your question to info@challalaw.com, and we'll send you the answer again. I apologize. So that's about it.
Thank you. Until next week, have a great week. Be safe, and I look forward to talking to you again next Wednesday.
Thank you.
Bye, Shaker.
Have a good day. Bye.